We are recording.
Thank you. Everyone to the appellate court. I'm Judge Joan Alexander, and I'm sitting today with Judge Suarez and Judge DiPentima. Were you able to record me? Because I got a message that came up. Lori, are we still recording?
There were moments of lag on my side, so it kind of.
Oh, sorry.
No.
I was muted.
That's
I'm still
okay.
recording, so you can just start up now.
Yeah, Dave, we got a message that we were being manually connected. At least that's what I saw on my screen for a minute. So I'm going to start again, just so that we have a full proceeding. And again, I'm Judge Joan Alexander. I'm sitting today with Judge Suarez and Judge DiPentima. This is the matter of HAMIDOVIC versus A Better Way, Appellate Court 43071. This argument is being conducted on Microsoft Teams. It is being live streamed on the Judicial Branch's YouTube channel, and the recording of this argument will be available on the Judicial Branch's website. To the extent that there is any protected information involved in this case, I would remind counsel that it should not be disclosed during their argument. To make sure we can all hear and see one another, I would please ask everyone to introduce themselves now, beginning with the judges, followed by counsel for the appellant, and then counsel for the appellee. Again, I'm Judge Alexander.
I am Judge Suarez.
Good afternoon, Judge DiPentima.
Mr. Votri?
Yes, okay. On behalf of the appellant, I am Kenneth A. Votri, and along with me in the room with me is my associate, Anthony Beal.
Thank you. Counsel?
Good afternoon, Your Honor. Richard Waring. I represent the appellee HAMIDOVICs.
All right, I was able to hear and see everyone, and I presume everybody else is able to do the same. If during the course of the argument you cannot hear or see anyone, please let us know immediately. Each of you received instructions prior to today's arguments. Do either counsel have any questions?
No, Your Honor.
No, Your Honor.
I'm going to ask everyone to please mute their microphones when you are not speaking so that we don't get any feedback. You must also keep your camera on at all times during the argument so that we know you are still present. If we have questions, we'll raise our hands, and if you don't notice us doing that, we will just jump in and ask the question. Everyone should be mindful that this is a court proceeding and conduct themselves as if they were present in the courtroom. Each side is permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal. The appellant should let me know before he proceeds if he would like rebuttal time, and if so, how much. Judge Suarez has agreed to keep track of time and will notify you when you have 2 minutes remaining and when your time is up. Attorney Votri, you may proceed, and would you like any rebuttal time?
Yes, I'd like to reserve 5 minutes, Your Honor. 5 minutes?
5 minutes. Okay, thank you.
Did you? You're hearing okay? Is that okay?
Yes,
okay.
We are.
All right. May it please the court. My name is Ken Votri. I represent the defendant appellants, A Better Way Wholesale Autos, Inc. In this case, the facts are pretty simple. In this case, the trial court dismissed the defendants, the appellants, application to vacate an arbitration award based on it not being filed within the statutory period set forth in 52-420C. The application that was filed on the basis of the Federal Arbitration Act and was filed within the 3-month time period applicable to the Federal Arbitration Act. And this case, and you know, in order to fully, of course, disclose, this case has a similar issue to the St. Paul case, which is now waiting for decision before the Supreme Court. That was argued en banc in this court. The distinction here between St. Paul and this case, St. Paul had an arbitration agreement that provided for the application of the Federal Arbitration Act. The arbitration agreement in this case does not select a law for purposes of the operation of the arbitration. So from the position taken by many federal courts, that once there is no designation of either the FAA or the state law, the applicable rules for the arbitration will be the FAA, and it will be the FAA unless the parties specifically agree otherwise. And the case law seems pretty clear that a general designation of a state's law, for example, would not be sufficient to do that. So under the FAA, the time period would be the three-month period. Now, the issue that comes up in Connecticut law is whether or not this time period is a procedural rule, which is subject to the subject matter, it would make it subject matter jurisdiction. That issue actually is before the Supreme Court on the St. Paul case. This court in St. Paul at the en banc argument, the decision, which was 6-2, suggested that it was in fact jurisdictional, and the two dissenting opinions and the dissent written by Judge Lavery took the position it is not subject matter jurisdiction. It is not, from our view, subject matter jurisdiction for a couple of reasons. And I do recognize that Connecticut courts have for years said it's subject matter jurisdiction. And I do remember in the Supreme Court argument getting a very interesting question, which was why? And I don't know. It's been that way for 30 years or more, and I don't know what the first decision was that did that. But the FAA, the time period, is clearly non-jurisdictional. Yes, Your Honor.
Attorney Votri, I'm kind of caught with your reference to the majority opinion in St. Paul.
Sure.
Saying that there was a suggestion that 52-420B was subject matter jurisdictional. Didn't we go farther than that?
You held it.
Yeah.
It was held. It was
That's
held.
the law of the appellate court right now.
As it stands
Agree
right
with
now.
that?
And that is true. And it is before the Supreme Court right now. And we can only guess where they might go.
But in terms of what's binding on us, this panel, would you agree that under Better Way versus St. Paul, we would be constrained to follow that holding as to 52-240B?
Well, I don't agree with that holding. It is the law of the state of Connecticut. It is the law, and you are bound by it unless you decide that you want to reverse your own decision in that case. And if you recall, the St. Paul case was argued en banc because it did have the effect of overturning the Doctors Associates case, which concluded otherwise. So I think.
But my point is, unless the Supreme Court disagrees or agrees with you and says no, it's not subject matter jurisdictional, we don't have, under the present state of our law, the ability to overrule that case.
Unless you were to do what happened in St. Paul and not decide the case and argue it en banc, you would have to go through extraordinary means to undo that decision. And when I argued that case, Your Honor, it was the only case I ever argued en banc, so I don't think it happens all that often. But at any rate, Your Honor, Your Honors, there is, in terms of subject matter jurisdiction, however, it doesn't matter in a lot of ways, and let me explain why. And this was what was argued at the Supreme Court in St. Paul case. What the U.S. Supreme Court has said is that a jurisdictional ruling of a court cannot be used to overcome the obligation of the state court to provide a forum to enforce federal rights. And of course, that came up, and that case is cited in, which I now temporarily forgot, but it's cited in my reply brief. And in the Supreme Court concluded, now within a context of a civil rights action in New York, concluded that there was, just one second so I can. Sorry, I've argued twice today, so I sometimes forget the cases. I do apologize. What was that case? That was, I jumped to a conclusion. Oh, it's in my notes, so let me bring it to you. Just one second, Your Honor. Haywood versus Drown. Haywood was a civil rights case, and the New York courts had precluded the ability to assert those claims before the state courts, claiming a subject matter jurisdictional defense. And what the Supreme Court held is that the state courts have a duty to provide a forum for the assertion of federal rights. Now, in this case, to apply that here, one would have to look at the application to vacate, and the federal FAA provides 3 months, and the state statute provides 30 days. And in several cases, the interpretation has been reached that if in fact the state law curtails the assertion of the federal right under the FAA, that it would be preempted by the FAA. As we know, the FAA is not a statute of general preemption, so it doesn't generally preempt state law. However, it does preempt state law that would have the effect of restricting the purposes of the Act. And the Act provides for 90 days. And I thought about this, yesterday when I was thinking about how I wanted to argue this case. One of the problems is that we would have a right under the FAA if we were in the district court, and we would raise our claim 90 days to apply the vacate. If this state restricts under the FAA the time period to 30 days, those people who bring claims between 31 and 60 days would be precluded from seeking to vacate their claim. So the Connecticut statutory application does in fact restrict rights under the FAA. And so it's a long way to get around to my argument, Your Honor. But in the issue of subject matter jurisdiction, well, I think it's a decision that needs to be made clear by the Supreme Court in the state of Connecticut. The state of Connecticut is precluding the rights of parties under the FAA to raise these claims between 31 and 60 days. So it does have the effect of putting the state statute ahead of the FAA. And so it does have a substantive effect. And the other thing is one of the arguments that are raised is that somehow that the rule is a procedural rule. Well, there is a body of federal case law, relatively extensive, that says once the FAA applies, that it is then presumed, subject to possible rebuttal, that the FAA's rules of conducting the arbitration apply, which would be the procedural rules. That rule can be undone by an agreement of the parties. And that was the St. Paul argument, that the agreement says what the agreement says, and so it has to be applied under federal law. Here, we're really not all that different. The FAA applies here because this is a contract that affects interstate commerce. And also the case law is pretty clear that if the FAA does in fact apply, then yes, go ahead.
On that point, why does this affect interstate commerce? Was there a finding by somebody, or are we to assume it because it's an automobile contract, or what? Why are we jumping right to the fact that the FAA applies?
Under the case law, it's relatively clear that it affects commerce, interstate commerce, if it simply has.
Okay, what case are you relying on to say that?
Sure, if you can, I can actually cite that for you. First of all, in the Supreme Court, 1 second, guys. I think if you looked at the Supreme Court decisions dealing with the FAA, Southland versus Keating, for example, in 1984, which started down the road of applying the FAA in the state courts, and also the cases that we cited in our supplemental authority that was submitted, the Duggan, Moyer, Mayo, and Oberswager cases that we sent in, and the Lex case, all indicate what the rules are in terms of interstate commerce. And it's a very easy test to meet. If you're selling a product into the stream of commerce, you are affecting interstate commerce. And the sale of automobiles, I don't think there's much question in any cases that I know of that is a sale within interstate commerce. It doesn't have to be sold out of state in order to affect interstate commerce. It's a very low test.
And that's what this Duggan case says, that selling
Duggan-
cars, or are you using Duggan to say that,
It's an example of a case that relatively, without much difficulty, concludes that it's interstate commerce.
okay.
But isn't this a used car sale? In other words, it's not a direct purchase from a dealer. It's a purchase from a second-hand seller.
Absolutely, Your Honor.
So that would be an in-state transaction.
Well, actually not, Your Honor, because a Better Way Wholesale almost buys exclusively their cars at auction out of state. So the cars all come into Connecticut from out of state. They're sold, and 1/3 of their sales is to the state of New York and state of Massachusetts. They cover the entire region. They sell 5,000 cars a year.
Yeah, but that's not the case for this particular plaintiff, right?
Yeah, but with all due respect, that doesn't matter. The issue is whether or not it's a sale in interstate commerce. Does it affect interstate commerce? It's the sale of automobiles affects interstate commerce. Even within the state of Connecticut, it's into the stream of commerce. So there's no law that suggests to affect interstate commerce, the sale actually has to cross a border.
So I guess that's my question. What border is it crossing?
It doesn't have to. It doesn't have to, Your Honor. What the case law basically says, it has to just have an effect on interstate commerce. So once you're selling automobiles into the stream of commerce, it has effect on the sales of goods. And you might ask, Your Honor, virtually, I shouldn't say virtually, the majority of transactions that are certainly commercial transactions affect interstate commerce. When I was trying to think about which arbitrations would not, affect interstate commerce, maybe an arbitration in a family case, in a divorce case, may not, but the sale of products into the stream of commerce affects interstate commerce. That's not a difficult place to reach in the analysis here. And if you look at the cases that I cited as supplemental cases, you'll see the varying types of transactions. Oops, 2 minutes. Thank you, Your Honor. 2 minutes. And so you'll see that it affects interstate commerce. And once it affects interstate commerce, the FAA applies. And what the case law says is the FAA, once it applies, is the rule of the case unless the parties agree otherwise. And and in fact, in the cases that we cited, there's some discussion of that. And I don't want to belabor you with reading quotes to cases. However, once the FAA applies, all the rules apply in this case. Now, what counsel's going to argue is, well, no, and with due respect to the St. Paul case at the appellate court, the Connecticut courts took the position that because it's subject matter jurisdiction, the court can't extend beyond that 30-day period, and it has no power to hear the case. What I'm arguing, though, is that the Haywood case makes clear that jurisdiction can't be an excuse to fully providing a full forum for the enforcement of federal rights. And the federal cases suggest that when you have a statutory period that defines your rights under that statute, it's substantive and not procedural. That defines a substantive right. And so under the existing law under the FAA, a number of the federal cases talk about procedural rules. They're not talking about the time period within which to bring it. They're talking about the actual rules that apply on an application to vacate as to what the standards are for vacating or not vacating an award. So I would suggest that this rule is a substantive rule. It is clearly a substantive rule in the federal court. And the other thing that I would say, Your Honors, is that, I'm sorry, do I have just 30 seconds to finish?
Yeah, you reserve time, so go ahead.
Okay, the one quick thing I want to say is that in order to look at the FAA, this court has to step into the shoes of the federal court, because you can't use the Connecticut jurisdictional rules to preclude rights under the federal statute. So you have to look at it from the federal view and not the state view. And this is actually kind of an interesting case. It is the spin on St. Paul because it's the case without an arbitration agreement that provided for the FAA. Thank you.
Thank you. Attorney Waring?
Can Your Honors hear me? Good afternoon, Your Honors, and may it please the court. I'm Richard Waring. I represent the HAMIDOVICs, who are the plaintiff appellees in this action. I'd like to start by addressing a question that Judge DiPentima raised. Yes, the jurisdictional issue has been decided. That was decided in St. Paul. It was based on 30 years of Supreme Court precedent, and it's not a mystery why the rule is jurisdictional. In the Middlesex case, the Supreme Court said that it's jurisdictional because, and we block quote this at page 4 of our brief, a proceeding to vacate an arbitration award is not a civil action, but is a special statutory proceeding. As a special statutory proceeding, it's governed by the rules of the statutory proceeding. And as we cite in our brief at pages 18 to 20, that is consistent across the law in this state where the General Assembly creates rights of actions, be it mechanics liens, appeals from probate. Strict compliance is necessary. It's a rule of general application, and that has been the law in this state with respect to 52-420B, at least since Middlesex, if not before then. So it is clearly jurisdictional. There are reasons why it is jurisdictional, and it's consistent with the broader body of Connecticut law. I dispute vigorously Mr. Vautre's assertion that unless the parties expressly choose state law, the FAA is the default set of, when you are talking about state court are all federal cases, and unremarkably, they say that in federal court, unless you specifically opt into another set of rules, the FAA applies. Those are all federal court cases. It makes sense. The Atlantic plating case that we cite in our brief, Supreme Court of Kentucky, points out that there's no indication that anybody ever intended those rules to apply in state court proceedings. And in fact, one of the cases that he relies on, Mr. Vautre, in his 6710 filing, Duggan, talks at length about whether or not the FAA or Missouri law applies, and he does a conventional preemption analysis. There is no choice of law clause in that case. It's not like they're saying, oh, well, no choice of law means the FAA. The cases that we cite in our 6710 brief, 6710 filing, Banson versus Dane Bosworth, which is a case very much like this one, Minnesota Supreme Court. Two parties to an arbitration. One signed a side agreement saying certain rules would apply. The other did not. Both lose. The party which had not.
Mr. Waring, Attorney Waring, can I just stop you for one moment? Can I stop you for one
Sorry,
moment?
Your Honor.
You are, we're losing you a little from the record. I think you're going to need to stay more consistent. And Mr. Vautry, I'm going to ask you to please mute yours so that if there is feedback, we're getting rid of that feedback. So I'm sorry to interrupt you. You can continue, Attorney Waring. So hopefully we're back in a position to record you appropriately.
I'm sorry, Your Honor. Thank you. Yeah, the Manson versus Dane Bosworth case, Minnesota Supreme Court, as I was saying, one of the parties hadn't agreed to rules, loses, seeks vacature in Minnesota State Court under the FAA and Minnesota law. It's untimely or improperly served under Minnesota law. It would have probably sufficed under the FAA. The Supreme Court of Minnesota says this is Minnesota State Court. Unless Minnesota rules are somehow preempted under a preemption analysis, Minnesota rules apply. Volt, the Supreme Court case, the leading case, says there's no interest in particular rules applying. The Minnesota rules apply. You didn't serve it properly under Minnesota. Minnesota governs. Now, you know, interestingly, I mean, the notion that somehow the federal rules, the default rule, is belied even by Judge Lavery's dissent in St. Paul, where he says that's the rule he'd like to adopt. He says that expressly in his dissenting opinion. If that's the rule he'd like to adopt as the dissenter, that strongly suggests that that is not the rule. And whether or not it was the rule before Your Honors decided, and clearly if just Judge Lavery is dissenting, saying this should be the rule, it's definitely not the rule after St. Paul. So the idea that the FAA is somehow the default provision in state court has no basis in state authority whatsoever. In state court, state rules apply unless somehow they are preempted by the FAA. We go through a preemption analysis in our brief. We point out how the Muscatello case in Pennsylvania dealt with this issue in the context of a 30-day period to challenge versus the 3 months in the FAA, and held there was no preemption. The Ekstrom case, which is a federal case that interpreted 52420B, said 52420B does not conflict with 9 U.S.C. 12 because even though the results might be different, the policy it serves is the same, which is expeditious judicial review. And in fact, expeditious judicial review is accomplished better by 52420B because there's less time to challenge. So, you know, the idea, and I'll leave it at the notion that somehow the FAA applies unless the parties have a choice of law clause to the contrary has no support, at least with respect to state court proceedings. State court procedures apply unless they are preempted because they conflict from the, you know, with the FAA under a traditional preemption analysis. So I think that's pretty clear. With respect to whether the FAA even applies in this case, seriously, everything Mr. Vautre said. There was no finding by the arbitrator in this case. There were no findings, period, in this case. None whatsoever about the nature of the transaction, the nature of the parties, the purposes of the transaction. It was an unreasoned award. And I'd refer your honors to A18 of Mr. Vautre's appendix. You can see that it's an unreasoned. At A26 of Mr. Vautre's appendix, you will see that the trial court made no findings whatsoever, none. It simply said it is untimely, it is dismissed. Had Mr. Vautre wanted to make an FAA argument, he could have asked the trial court for findings, right, that would allow him to argue that the FAA controlled. He could have tried to present evidence. He didn't. He hasn't moved for rectification. He didn't move for articulation. There are literally no findings of fact about anything that would support the application of the FAA. The nature of the transaction can only be gleaned from things that aren't findings of fact, which is to say the evidence that was submitted. But as we point out in our brief, evidence is not findings. Evidence might be evidence, but in and of itself, they're not findings. And your honors, I would point you to footnote 13 at page 10 of our brief. This is exactly what happened in the Gavlet case, which was a Third Circuit case. There were no findings of interstate commerce, and the party seeking to invoke the FAA said, of course, your honors, this is exactly the sort of thing. It's a partnership agreement. It's a dispute over partnership. Of course, it implicates interstate commerce. And that's Gavlet, the Third Circuit said, we don't make that presumption. The absence of these findings precludes our consideration of the applicability of the Arbitration Act. Although it is certainly possible, and this is what the decision said, that the partnership agreement of a brokerage firm dealing with securities involves interstate commerce, we cannot make this assumption without a proper factual predicate. There was no factual predicate in that case. There is none in this case. And, you know, as a law professor I had when I was in law school said, when someone says it's obvious, that it's usually not that obvious. So to say, well, it's obvious this is interstate commerce doesn't change the fact that there were findings of fact. And absent those findings of fact, the FAA could not apply regardless of whether it preempts. It just can't apply coming out of the, if you'll excuse me, or just for 1 second. I would say, then your honors, if the FAA could apply, we've done our preemption analysis. Like I said, Monticello and Ekstrom, which brings me to really which is the linchpin of Mr. Vautre's case, is the Hayward versus Drown case. And that case has literally no application to the Supreme Court expressly limited that case to its particular, and I'd like to read your honors as soon as I can find what
Mr.
the
Waring,
Supreme Court said, because
I'm going to stop
it
for a
really
minute.
slams the door.
Again, you cut out right when you were talking about
Applies well beyond. I'm sorry, Your Honor.
you're going to need to start your analysis of Hayward again because you were cutting out. Thank you.
Oh, I'm sorry, Your Honor. Okay, Hayward versus Drowned was limited expressly to its fact.
For some reason, Mr. Waring, you're frozen.
Honors from 5.
I know we have the video assistant on from the appellate court. Should we have him log in and log off because of this frozen screen?
Your Honor, he might be not near, he might be
Constitutional.
remote too. He
I'm
needs
sorry,
to
Your
be
Honor?
close to his monitor.
Oh, okay. Is that better?
Yes.
Okay, sorry about that. The Supreme Court said the dissent's fear that no state jurisdictional rule will be upheld as constitutional is entirely unfounded, and then goes on to limit the case to its facts. That case is limited to its facts, has no extension beyond it. If Your Honors were to try to compare, first of all, 42 U.S.C. 1983 is a jurisdiction creating statute. It can create jurisdiction in both state and federal courts. AA does not create jurisdiction. That's clear. It requires an independent jurisdictional basis to be brought into action. That's the Moses H. Cone case. You have to have a jurisdictional basis to even talk about whether the FAA applies. So how can a statute which doesn't create jurisdiction, it's not the same as a statute which does, that New York then tended to divest. Other peculiarities in the Hayward case, the Supreme Court remarked that case really wasn't so much a jurisdictional rule as it was an immunity statute for corrections officers that was guised as a jurisdictional limitation or a jurisdictional bar. The other thing was, if you compare Hayward versus Drowned, you're talking about a deliberate, and the Supreme Court really shows this, it was a deliberate attempt to thwart federal policy in favor of a contrary New York policy. Well, that's not the case here. Federal policy doesn't require the application of 9 U.S.C. 12. It only requires that arbitration agreements be enforced according to their terms on the same principles that other contracts are enforceable or are unenforceable. So what's the federal policy that's being thwarted? And 9 U.S. and 52.420b applies equally to all kinds of cases. Doesn't matter where the arbitration comes from, that rule applies. And the rule that time limits are jurisdictional isn't peculiar to arbitration. That applies across our law. If you're 1 day late foreclosing a mechanics lien, the trial court has no jurisdiction. An untimely appeal from probate is untimely. A notice to quit that isn't properly served and an action to evict that isn't properly, commenced in relation to notice to it, there's no jurisdiction on any of those things. So, even if you're going to compare Hayward versus Drowned, Hayward versus Drowned talks about one statute deliberately designed to, destroy jurisdiction with a particular class of plaintiffs and defendants. We're talking about a statute of general application that's consistent with an entire body of state law and has no pernicious purpose. And in fact, its purpose, to limit judicial challenges, to arbitral awards, is the same policy that's in 9 U.S.C. Section 12. It's just Connecticut is more aggressive in enforcing arbitral awards because it makes it harder to challenge them. So I don't think there's anything to be gained by Hayward versus Drowned. I think it has absolutely no application to this case, and is a red herring, Your Honors. I don't know how much time I have left, but I'm happy to entertain Your Honor's questions if Your Honors have any questions. No? Judge Suarez, how much time do I have left?
I did stop the clock when we couldn't hear you, so you still have 8 minutes. 7.5 minutes.
7.5 minutes. I guess the only thing more than I would say, I think I've covered preemption. I think I've covered my 6710 filing. I will say something about ABW's 6710 filing that they made. They cite two Missouri cases, Duggan and Mueller. Both of those cases dealt with an agreement to arbitrate covered by the FAA, whether it could be enforced because it didn't comply with a Missouri law that required the statement, this contract contains a binding arbitration period provision which may be enforced. Both courts held that that's inconsistent with 9 U.S.C. Section 2, which says you don't have any special rights to enforce an arbitration clause beyond what is required in general for contracts. And in fact, in Duggan, the court did a preemption analysis just the way we did a preemption analysis in our case, and said that, it went about it in the same way. It was a conventional preemption analysis, and that's what Duggan was about. It was not saying that there's a default rule to the FAA. It's these are the rules, but if it conflicts with the FAA and undermines the policies of the FAA, it is preempted. Oberwaxer and Lex, these are both federal court diversity case. There was no agreement to whose arbitration law governed. The court deferred to the general rule that in federal courts, the FAA applies unless the party specifically select otherwise. That makes perfect sense. It's federal court. You would assume that federal statutes and procedures apply, potentially with some choice of law exceptions. That's not this case. And finally, in Mayo, that case had nothing to do with California law having been preempted by the FAA. In that case, the parties agreed that New York law and the New York Stock Exchange arbitration rules through 14. The district court concluded that 9 U.S.C. 2 required the court to honor the party's choice of law and procedures rather than apply the California law that one of the parties wanted to apply. It's not about preemption, it's about choice of law. And that case probably has the least to do with any of the cases other than Hayward versus Drown that A Better Way relies on in this proceeding. And I think it provides no insight whatsoever into how to resolve this. And I'll conclude by saying this, Your Honor. This is a very straightforward appeal. The question before the court is simple. In the absence of a choice of law clause that specifically provides for the application of the FAA, do FAA procedures control, or do the general statutes and the procedures they create control? ABW offers no authority saying that the FAA controls in state courts as a general matter. And from a preemption perspective, they have nothing which rebuts the preemption analysis that we've done. I think the case is crystal clear. The trial court acted properly, and this court ought to affirm on the same basis. And if you have no questions, Your Honor, I'll cede back the balance of my time.
Thank you, Attorney Waring. Attorney Votri, you're off of
Your
mute
Honor.
if you'd like to conclude in your rebuttal.
Thank you. First of all, let me talk about the Haywood case. The Haywood case absolutely applies here. And if you look at the quotations we put in our brief from Haywood, relying on a case, Taplin versus Levitt in the Supreme Court, says this: we have emphasized only that a neutral jurisdictional rule will be deemed a valid excuse for departing from the default assumption that the state's courts have inherent authority and are thus presumptively competent to adjudicate claims arising under the laws of the United States. And the beginning of that paragraph says, so strong is the presumption of concurrency that is defeated only in two narrowly defined circumstances. First, when Congress expressly ousts the state's court's jurisdiction, and then it goes on to say when a state court refuses jurisdiction because of a neutral state rule regarding the administration of the courts. Otherwise, this court can't preclude the enforcement of the rights under the FAA. And 2 months of that time period of any claims filed to vacate within that period of time are being precluded here. It is a violation of the supremacy of the cause of the United States, and it is contrary to the Haywood decision. So Haywood, yes, was a civil rights case, but it cites a number of general precedents in the Supreme Court. So I would say that. Secondly, the Muscatella case and the Ekstrom case both those cases are not applicable here. And the reason is the ultimate finding in those cases is that there was an agreement to apply the state rules. The exact opposite of this case. In this case, we have the application of the FAA, and the FAA is applicable in this case because if you look at the record before the trial court, every single document submitted in the arbitration was before the court, is part of the record in this case, and it clearly reflects an automobile transaction into the stream of commerce. No more is necessary to demonstrate that the Commerce Clause is applicable to this case. It is as simple as possible, and the finding doesn't have to be made. The record is clear on its own before you that this transaction was a transaction in commerce, and the arbitral decision essentially supports that. Well, it's not a reasoned decision. It is a decision on the basis of the sale of automobiles, and only the sale of automobiles is sufficient to be covered under the Commerce Clause. Let's see, and I'm going to try to read my notes here too. Jurisdiction. Counsel said something that's not correct. You do not need to establish jurisdiction in order to demonstrate that the FAA applies. That's utterly incorrect. I think what counsel was trying to discuss was in order for the federal courts to hear an application to vacate, there has to be an independent jurisdictional ground, either diversity or federal question, for the federal court to hear the case. That argument is what is in favor of the appellant here, because in this case, if you have two parties from the state of Connecticut, you can't get to the federal court on diversity. You could get there if there's an underlying federal question, but in many cases, what will happen is that you're in the state court asserting your FAA rights because you don't have diversity or federal question. Because what I think counsel was trying to explain is the FAA doesn't create its own federal question jurisdiction. And that's one of the important things when we look at whether or not there is preemption and whether or not our rule at 30 days is one that puts the FAA behind the state rule, because two parties with exactly the same claims, with the same contractual provisions, except one lives in New York and ABW's in Connecticut, one lives in Connecticut and ABW's in Connecticut, would both have to go to different courts, and each of those courts would enforce the FAA differently. Connecticut would hold the party moving to vacate to a 30-day rule, and it would be I shouldn't say 90 days, 3 months is what the rule says in the federal rule. Those two Missouri cases that were referenced by counsel, if you look at them, one of them says, and what it says is, if in fact the application of the state rule essentially treats the matter differently than the federal rule would, then it leads to preemption because you're achieving a different result. Time out. Thank you. I'll stop talking. Thank you so much.
Thank you both, counsel, for your arguments. We will take this matter under advisement, and we are adjourned for today, reopening tomorrow at 9:30 a.m. for arguments. Have a good night, everyone.
Good night, all. Bye-bye. Nice seeing you.